Good morning, everyone. So my presentation is in relation to where the topic of safeguards falls into the question of constitutionality in relation to any such legislation which may be introduced in Ireland in the not so far future. So the current prohibition of assisted dying in the Republic of Ireland derives from the Criminal Law Suicide Act 1993, which decriminalised suicide but maintained a prohibition on assisted suicide, or what is now best referred to as assisted dying. 20 years later, in 2013, Marie Fleming issued judicial review or legal proceedings to challenge the constitutionality of the 1993 Act on the basis that she had a constitutional right to determine how she died, drawing on principles of bodily integrity and autonomy, and on the basis that the 1993 Act discriminated between able-bodied persons and persons with disabilities, as the Act decriminalised persons ending their own lives, but made no provision for persons wishing to do so and achieve the same outcome, but who required the assistance of another to achieve that same outcome. The matter ultimately came before the Supreme Court, who held that the state has a positive obligation to protect life and that the Constitution did not imply a right to die or a right to determine one's own death. The court indicated that the decriminalisation of suicide did not constitute the invention of a right to die, as it was suggested that the reason behind the 1993 amendment was for the purpose of removing the stigma associated with suicide, not to promote or facilitate the ending of one's own life. The court therefore refused to invalidate the 1993 Act. However, while the court refused to invalidate the Act, former Chief Justice Susan Denham stated the following passage at paragraph 108 of the judgment. Nothing in this judgment should be taken as necessarily implying that it would not be open to the state in the event that the Oireachtas, which is the Irish Parliament, were satisfied that measures with appropriate safeguards could be introduced to legislate to deal with a case such as that of the appellant. If such legislation was introduced, it would be for the courts to determine whether the balancing by the Oireachtas of any legitimate concerns was within the boundaries of what was constitutionally permissible. Any such consideration would necessarily have to pay appropriate regard to the assessment made by the Oireachtas, both of any competing interests and the practicability of any measures thus introduced. Therefore, while the Supreme Court refused to recognise a right to die from within the Constitution, the Supreme Court has suggested that their decision should not be taken as implying that it would not be a possibility for the Irish state to provide for assisted dying by way of legislative intervention if it was satisfied that measures with appropriate safeguards could be introduced. As a result, one could describe the legal framework in which we are currently operating in the Republic of Ireland is that while there is no constitutional right to avail of assisted dying, the state can nevertheless provide for assisted dying for persons in similar circumstances of the late Marie Fleming, subject to the implementation of appropriate safeguards. The topic of safeguards is therefore central to ensuring that any such legislation which the state may seek to introduce is constitutional. The balance to be struck is in providing for a robust and rigorous regime which vindicates one's right to self-determination and one's right to bodily integrity, while also protecting the right to life of all other persons, namely vulnerable persons who may be perceived as at risk in the event such legislation was introduced. Without adequate safeguards, any legislation enacted by the Oireachtas to provide for assisted dying could be challenged and invalidated by the courts. The prevalence of safeguards was visible following the publication of a Justice Committee report in July 2021, which scrutinised the Dying with Dignity Bill 2020, a previous bill commenced in 2020 to provide for assisted dying, which the Justice Committee report said could not proceed on the basis that it did not include sufficient safeguards to protect against undue pressure being put on vulnerable persons to avail of assisted dying. Subsequently, in early 2023, following the recommendations from the aforementioned Justice Committee report in 2021, a joint committee on assisted dying was established to consider and make recommendations for legislative and policy change related to a statutory right to assist a person to end their own life and a statutory right to receive such assistance. After convening 24 public hearings on the topic, which invited national and international experts in law, ethics and medicine, on the 20th of March 2024, the Special Joint Oireachtas Committee released its report, in which it made 38 recommendations, namely that assisted dying be introduced for persons diagnosed with a disease, illness or medical condition that is A, both incurable and irreversible, B, advanced, progressive and will cause death, C, expected to cause death within 6 months, or in the case of a person with a neurodegenerative illness or condition within 12 months, and D, causing suffering to the person that cannot be relieved in a matter that the person finds tolerable. The regime proposed by the committee, therefore, is not to establish a right to die for all, but seeks to establish a right for those who are already approaching the end of their lives in challenging and unfortunate conditions to bypass their own pain and suffering and to die compassionately. As a reflection of their importance, the report includes a specific chapter dedicated to safeguards and highlighted key concerns, namely coercion, consent and capacity, which paint the backdrop of the hurdles the Oireachtas must overcome to ensure that any legislation they wish to introduce is constitutional. In turning to the first of those concerns, coercion became a recurrent discussion and is one which has been addressed by the committee in its report, through which it provides recommendations to mitigate any such risks. In her submission, Dr. Andrea Mulligan, barrister at law, advised the committee that ensuring that any decision to request and avail of assisted dying is incoerced and free from external pressures is one of the most difficult things to achieve in practice. Further, Dr. Sinead Donnelly, a palliative care doctor in New Zealand, warned that coercion is subtle and happening regularly, which is something that is not tied to class. She cited examples of financially stable individuals who want to die in their own home, but whose partner does not want a nurse in their home, and that as a result the patient will choose assisted dying. However, the committee also heard from several witnesses that attempts at coercion can be detected and screened for if the application process for assisted dying is properly set up. Dr. Kristen Good from New Zealand told the committee that in New Zealand, suspected coercion is investigated and documented at each stage of the application process, and that this is then reviewed. Dr. Greg Mewat also advised the committee of the Australian experience, in which people are in fact being coerced away from assisted dying rather than being coerced into it. Dr. Cameron McLaren, also from Australia, further advised the committee that coercion is not something they are having problems with. Accordingly, in view of the evidence given in relation to coercion and in order to address those concerns, the committee made the following recommendations. Recommendation 4 recommends that where a person has been proven guilty of coercion, they will have committed a criminal offence. Recommendation 5 proposes that doctors and healthcare workers involved in the provision of assisted dying be trained to the highest level possible to identify coercion when assessing or treating a patient. Recommendation 6 recommends that if a medical professional has been proven to have acted outside of the permitted regulations or has attempted to coerce an individual, they will have committed a criminal offence under the potential legislation and may be held liable. Finally, Recommendation 7 proposes that any enactment which provides for assisted dying will include a mandatory reporting regime to An Garda Síochána, Ireland's police force, of any information or evidence concerning the issue of possible coercion in relation to assisted dying. In terms of societal coercion, the committee acknowledged that if an individual approaching the end of their life cannot access supports necessary to remain in their own home, they may feel pressured to access assisted dying. Sinead Gibney from the Irish Human Rights and Equality Commission addressed this concern in her submission and said that the most important protection against people feeling coerced into seeking assisted dying is to ensure that social conditions, support, care, and services are in a place so that people with disabilities or serious or terminal illnesses do not feel that they are a burden to their loved ones or to society. She further stated that this is something that goes beyond adequate funding and access to health and social services and must include active efforts to create a society where people are able to live life on equal terms, free from discrimination. Therefore, it is apparent that the state must seek to ensure that those living with a terminal illness or neurodegenerative condition are able to avail of alternative options in order to ensure that they can continue to live their lives, if they so wish, without discrimination, and are in receipt of all the required services that they need in order to continue to live their life with dignity, through the provision of adequate palliative care facilities and more supports for those who are disabled so that they do not feel that they are a burden. These are concerns which cannot be directly tackled through legislation, but the committee did make recommendations in relation to reviewing palliative care services and ensuring that palliative care and assisted dying are dealt with independently and separately by the state. The next issue, which then arises in the context of safeguards, relates to capacity and the ability to give informed consent. In that regard, Dr. Louise Campbell told the committee that informed consent is the voluntary, uncoerced authorization of a medical intervention by a person who has capacity to make a decision on the proposed intervention and has received adequate information to enable her to make the decision. Dr. Campbell recommends that borderline capacity, where capacity is in doubt, should result in exclusion. Accordingly, recommendation 8 of the report proposes that where capacity is in doubt, a functional test for decision-making capacity should become part of the assessment for eligibility for assisted dying, while recommendation 9 proposes that any doctor involved in determining eligibility for assisted dying would have professional training in assessing capacity and voluntariness. Having looked at capacity, the committee then turned to a scenario where capacity is not an issue at the time of the making of the request, but subsequently becomes an issue where capacity is lost in the intervening period before the medical assistance in dying is administered. In those circumstances, the witnesses before the committee shared the overwhelming view that those seeking assisted dying should have to retain their decision-making capacity up to the very point of the procedure. The committee looked at other jurisdictions where individuals must make a final and clear request or accession to the procedure directly before the medication is administered. Accordingly, recommendation 10 of the report proposes that if a patient temporarily loses decision-making capacity, then eligibility is suspended for the duration of their incapacity, and they would not be able to avail of assistance until capacity is restored. As a result, it would therefore appear that if the totality of safeguards as recommended by the Oireachtas Committee are incorporated by the legislature, that Ireland could soon be on track to introduce assisted dying legislation with robust safeguards which would appear to pass the test of constitutionality with reference to the comments of the Supreme Court in the Fleming judgment. This would ultimately mean that, in the words of Lady Hale from the UK Supreme Court, we could depart from the current position where people are forced to stay alive, not for the sake of protecting themselves, but for the sake of protecting other people, in a way that strikes the adequate balance between protecting vulnerable persons and vindicating one's right to self-determination and bodily integrity. Thank you.